I would like to strongly oppose and propose that this clause be deleted in its entirety, because the ruling of the Supreme Court was clear that by the operationalization of this, it is clearly unconstitutional. So I would like to move that the entire clause be deleted.
First read the clause before you say it is deleted.
The entire clause 29, and as it reads, that members of the defense forces subject to military law. I further re-echo that what we are talking about is subjecting people to the military court-martial that was considered unconstitutional by the ruling of the Supreme Court. So you can have your proposal. My proposal is that we delete it entirely. So move your proposal. Right Honorable Speaker, I move that we delete this entirely. But the Honorable Otafire is seconding me.
Honorable Mehdi,
I move that we delete the entire clause.
Honorable Mehdi, this is in relation to members of defense forces subject to military law.
Even that one, I move that we delete this entirely. And the Honorable Otafire wants to second me.
Is it seconded?
Honorable Du is here seconding me.
Seconded by Honorable Du. Yes? You come to the microphone.
Is it in order for my friend, the Honorable Nsereko, to tell lies that I second him when I'm here speaking alive and I'm not seconding him? Is it in order?
Honorable Nsereko is not in order to impute that you're second.
We pass this provision, it's better for members to understand. The reason why Honorable Nsereko has raised this matter is that the judgment of the Supreme Court had said that even militants or soldiers, when they commit certain offenses, they should be brought to the civilian court. Now, the definition of the military law, here we have used the word military law, but the interpretation of the military law is that offenses under this act, which offenses under this act are so many, but also includes the murder and etc., are now termed military law. So the court had ruled that even when soldiers commit certain offenses, those offenses are still triable by the civilian court. And when I was presenting the minority report, I made reference to a judgment that came out yesterday, where there was murder committed by a member of the military. And still, yes, in the definition here, deserters and even a person who has retired is still a military officer. So that's why he was saying delete in the light of the judgment. Which
Honorable members, we must make a decision and saying that we must delete section 29. And I'm going to ask a question that those in favor of deleting section 29, say aye, and to the contrary, nay. Aye. The nays have it. Honorable members, I put a question that clause 29 stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 30.
30.
Madam Chair, clause 30 is an insertion of section 117 in the Principal Act. Clause 30 of the bill is amended in the proposed section 117A, 1A by deleting paragraph C. B by substituting for paragraph D the following: where the person aids or abates a person subject to military law in the commission of or conspires with a person subject to military law to commit a service offense. C, by inserting immediately after the proposed subsection 10 the following: for purposes of subsection 1F, Roman numeral 2, classified stores mean items prescribed in Schedule 7B to this Act and have a marking logo, insignia, regalia, serial number, or anything that can identify the classified stores as belonging to the Defense Forces. The justification is to comply with the decision of the Supreme Court in Constitutional Appeal number 2 of 2021, Attorney General versus Honorable Michael A. Kabaziguruka, wherein court found that trial of civilians in courts martial is unconstitutional for vagueness and recommend that civilians can only be tried in exceptional circumstances. Paragraph C is deleted since it is a repetition of paragraph F to clearly define what amounts to classified stores.
I would like to say what is good for the goose is good to the contrary, even for the gander. What my colleague is talking about is apparent. People are picked up in civilian cars during operations and with people that cannot be easily identifiable. However, the committee has pointed out something worth noting, Right Honourable Speaker. The issue of what should be considered as a military attire to include the logo of the military. So if someone wears a cape that is merely red without a logo and serial number of the production or collection batch of the military, then those people should not be subject to this law. Then secondly, Right Honourable Speaker, the Supreme Court was very clear on the matter of civilians, and let me make it clear. At times, people travel with military personnel who are performing certain duties. At times, it's not official operations. And these people may make errors or may make omissions, but I'm in their company. It's not necessarily that it's adduced that I'm aiding and abetting the commission of this offense. However, when people are rounded up, they are rounded up in a group. So I would like to say, Right Honourable Speaker, that we maintain the position of the Supreme Court ruling and make it clear that we reject the trial of civilians in military courts. And therefore, I would like to move, Right Honourable Speaker, that we reject this clause in its entirety and uphold the position that you've passed in the earlier clause that is only military officers, and would like to recommit that those that are retired, that are no longer serving, there is no order.
Thank you.
Order?
Thank you.
We don't
members, the committee
that
says,
we delete it.
The committee says we delete part C of the of clause 30.
Madam Chair, for me, I propose deleting the trial of civilians in a military court. Why is it? But Honorable Otafire.
Honorable members, I put a question that clause 30 be amended as proposed by the committee. Those in favor say on the contrary, nay. The ayes have it.
Clause 30 as amended.
I put a question that clause 30 as amended stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 31.
I put a question that clause 31 of the bill stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
192 of the Principal Act. Clause 35 of the bill is amended in the proposed section 192 A by substituting for the proposed subsection 3 the following. The chairperson of a unit court-martial shall be appointed by the commander-in-chief in consultation with the Judicial Service Commission from a list of persons approved by the High Command. B, in the proposed subsection 9 by deleting the words or any other written law. C, by substituting for the proposed subsection 10 the following. The chairperson and other members of a unit court-martial shall serve for 5 years and are eligible for reappointment. D, by deleting the proposed subsection 11. And E, by substituting for the proposed subsection 12 the following. The decision of a unit court-martial on matters of A, law and procedure shall be determined by the chairperson, and B, matters of fact shall be determined by majority members. By deleting the proposed subsection 13, And then G, in the proposed subsection 14, by substituting the words general court martial, the words division court martial.
Thank you.
Justification for clarity and better drafting, deleting the word other written law is a constitutional amendment arising from the amendment of the definition of service offenses under clause 1, to provide for reasonable tenure of office for efficient discharge of justice, to designate the division court martial as the first court of appeal from the decisions of the unit court martial in order to bring services closer to the people.
Thank you.
The amendment to the proposed section 12 is provide clarity on who is supposed to appropriate decisions, on who is supposed to make appropriate decisions in the court. The other justification is to comply with the decision of the Supreme Court decision. Thank you.
When you look, refresh our memory with the decision of court. One of the issues that was before court was that members of the court martial do not have the requisite legal qualification. So I want to bring to your attention this scenario. It is proposed here, there shall be a unit court martial for each unit of the defense forces, which shall consist of any 3 of the following persons, including the chairperson. The chairperson who shall be at that rank. When you go down, it is only the chairperson who has the qualification, the legal qualification. The 2 others do not have that qualification. And because there are 3, the decision is by majority. So the 2 non-lawyers, the non-legal persons, are the ones deciding. So it takes us back to the issue annulled by court. So my proposal here is that if we want to implement the decision of court, all the 3 panelists must be qualified legal persons. That is the correct interpretation. Otherwise, we are going round in circles. That's the first one. That's the first issue I want to raise.
That is amendment of 6 to include the qualification.
35. So the submission is
35(6).
Yes, all the 3 panelists must be persons with legal qualification. That's the first one. The second one, under 35, which I invite the attention of the House. The reason why the decision of the court was that the court martial is, as it is constituted, cannot be delivered justice, relates also to how they are appointed.
Actually, you can amend 2 to include the qualification, both, because it talks about the chair, then you talk about the other 2 members.
Yes. So court analyzed and found that a serving army officer is not immune because they will take 2 oaths. They will take 2 oaths. The judicial oath to deliver justice, but also the oath taken by soldiers to obey their next commander. So of these 2, court found that there will be conflict. If I am still in an army officer serving, I am under duty to execute the command by my superiors, including the command of the high command, which is the appointing authority. So if you allow me finish, and then you clarify.
You are finishing wrongly. Yeah. Yes. Whereas we could be tempted to, I followed him very well. The only other thing is that, first of all, we have to admit that these officers are UPDF. They are soldiers. So you can't say they can only take 1 oath. The temptation we have is to make these courts martial to be like civil courts. That temptation, let's try to resist. We've made big, huge compromises by having all the units, division, and the general court martial, to have lawyers, people qualified to be advocates. That's the first time in the history of Uganda. So this other part of saying they should do taking command from the high command, when they take command, they would be taking as soldiers, not as in matters relating to what they are educating about. So I don't want you to finish, take long to finish and also finish wrong.
Honorable, both. Honorable, maybe you could also address yourself to clause 45, 202C on independence of court martial.
The issue of independence, first we are involving, we trust the Judicial Service Commission to help us vet. When we say in consultation, again, it is the first time that the military is involving civilian body, constitutional body that vets all the lawyers, all the judicial officers, to vet and give us names. And also, too, we have a department which will be different from the normal command and control, a department of administration of justice in the military. That has never happened, and it is not a command structure. That is an administrative structure. I want to plead to Honorable Odur and Honorable Ayatollah, the landlord, to take it in good faith that we've made serious baby steps to give effect to the Supreme Court. And if there was anybody to doubt, you wouldn't doubt the Attorney General here, who has spent sleepless nights. So this is in good faith. Let's take it as it is so that we can give effect. And if we have any other problems, we shall come back to you.
Proposed amendments by the committee.
Madam Chair.
What about the one of Odur on the qualification of the other two members?
Well, on the qualification of the other two members, Honorable Odur, we thought about that, and it's not new in our place here. I'm sure you are familiar with, say, the industrial court. The industrial court has one lawyer and two other people who are experts, assessors, experts in labor issues. Yeah, and these are experts in army affairs. So we're not picking people from the street. But here the law has told them that the only person, and the amendment has clarified it, the decision on matters of law will be made by only the chairperson who is a legal expert. But the decision on matters of fact can be done by the soldiers, and I think it is perfectly fine.
Yes, Mehdi.
General, you are talking here about criminal law, criminal trial. The highest standard is needed before court. Industrial court, tax appeals tribunal, these are civil matters, and the burden of proof is on balance of probability. But here you are talking about criminal, administrative. Yes, about issues of life and death. Somebody going to prison, somebody going to spend 6 months and etc. If we want to align with the decision of the court, for example, we could have only provided for one judge, like a chief magistrate, and don't bring these two who are not qualified. If we pass it like this, it will be easy for court still to nullify. How do I subject myself to a panel constituted of people who supposedly don't understand the law, who do not have qualifications?
Honorable Attorney General, so you cannot have compare. So many lawyers in the army. Yeah.
Right, Honorable, getting the purpose of this unit. We are talking about law, experts in law. What about the experts in army business? What about experts in war? Because the unit court martial is not only dealing with matters.
Honorable Attorney General, there are soldiers who are lawyers.
Yes.
Chair, the expert, the Land Attorney General is an expert during a trial. You invite him as a witness to convince the one that is passing justice that this person is the expert you've presented. So which expert are you talking about? Because you should be talking about an expert in law. not an expert in military affairs. During a trial, if any side wants to present an expert, it seeks leave of court to present an expert to support its case.
Honorable Minister.
This is Honorable Medi is also a lawyer. And we practice criminal law in Uganda. We have assessors. Assessors are picked from the members of public. Now in this, because that's the temptation I try to say we should avoid. If we use the word assessors here, it would be like we are in a civil court. Now the political commissar has a specific duty. The administrative officer has of the unit where this officer must be there when they are trying his officer or her officer. So that is why they are there, but with one lawyer. But should it be the wisdom of this house that you want to remove them and you replace them with the lawyers? We have enough lawyers, but they were playing very core, critical administrative functions. They must give, in fact, not only that, there's an administrative officer of the unit, a political commissar of the unit, a regiment sergeant major. Now, this is where, when I am not surprised when Honorable Nsereko is asking me to do what. That's the real difference. I could have asked that question 4 years ago before I got to know about what the military does. These people are different. They are not the same. These people are very different. Let's help them.
Honorable members. Yes. Honorable
Madam Chair, the question I'm putting to my senior land council and honorable member is you're creating a jury here. And the issue you're saying is you're presenting experts in administration of justice under criminal law. But like you've said, you've clearly stated that the chairperson is well equipped with the tools of law, meaning the following will be his advisors. Therefore, if someone is being presented before an impartial
the following
court,
will be picked from B, the administrative officer of the unit.
Exactly.
The political commissar of the unit.
Exactly.
The sergeant and then the junior officer.
And Madam Chairperson, our argument is, if they are experts as the other side proposes, then let them come in as witnesses to support their case. No. Yes, because this is a court.
Tony.
You're not setting different rules.
Tony.
Thank you.
Why is General Jim Mwezi agitated?
Thank you
very much, Madam Chair. Madam Chair, the issue of elevation of this to a High Court judge, remember, High Court judges or an equivalent is not only subject to recommendation by the Judicial Service Commission, but also the Parliament of Uganda.
That is where? The chairperson of the division court?
The Parliament of Uganda, being an equivalent. The
Medi,
chairperson.
Medi, just a minute. The chairperson of the division court martial shall be an advocate of the High Court. You're saying a judge.
The amendment was saying something else. And what we are proposing, Right Honorable Chair, is that this continues to defy the orders of the Supreme Court. And our proposal is to move that the whole clause be deleted. And I move a motion that the clause be deleted. And Honorable Odur is seconding. Even Honorable Otafire.
Honorable Odur.
You will second me.
Madam Chair, I have two issues here. The first one is the same as the concerns I raised about having two members in the panel, which under Clause 8 says a panel constituted under subsection 7 shall hear and conclude the trial for which it was constituted, meaning still that two non-legal persons, as found already by court, will still sit there to determine a criminal matter. But the second issue that is important for us to reflect on here, Madam Chair, is that court, in arriving at the decision to declare the court-martial impartial, looked at the issue of tenure, security of tenure of the persons making this decision. The moment you say reappointed, you have already compromised my ability to deliver. I will deliver justice at the back of my mind, knowing that after 3 or 5 years, somebody else has control to appoint me. So it is interfere. So what the Supreme Court had recommended was that the appointment of all the judicial officers under the provisions of the court-martial should be to the level as their counterparts who are in the civilian authority. That will ensure that if I am appointed a judge in the court-martial for that entire period until my retirement, I don't have to worry about the reappointment and the subject. So my submission is that as it is here, it does not address the concerns that was raised. These judicial officers here should be appointed in a manner that guarantees their security of tenure.
Do you want them to be permanent until retirement?
That's what the Supreme Court said, not me. That was the finding by Supreme Court, that if you appoint someone on a probationary, temporary, subject to something else, they cannot dispense justice. The impartiality and fairness required of them is clouded by their worry to be reappointed. So it is them to address it, but if they don't wish to address it,
thank you.
Madam. Also, but to the contrary, the army operates differently. They retire, a private may retire at the age of 40. Their retirement is tagged to the ranks. So going by that proposal, it would be very, very difficult to give effect to that. Because if you are a colonel maybe retiring at the age of 55 or something, you have to go. So we agree to the amendments made, the improvement made by the committee, moving from 3 years to 5 years and then making it open. So the person will be renewed, and the committee proposed the renewal.
Madam Chair.
Without any condition.
Madam
I think
Chair,
that makes us comfortable.
Madam Chair.
It is not a fixed term.
Madam
I
Chair,
put a question that clause 36 be amended as proposed. Those in favor say on the contrary, nay. Yes, have it.
Clause 36 as amended.
I put a question that clause 36 as amended stands part of the bill. Those in favor say on the contrary, nay. Yes, have it.
Clause 37.
I put a question that clause 37 stands part of the bill. Those in favor say on the contrary, nay. Yes, have it.
Clause 38.